All right, well, good morning, everyone. It's a beautiful December 28th morning, 2021. My pleasure to visit with you. We get together with our distribution partners most weekday mornings at this time to review strategies, tips, techniques. Really what we focus on is listening to you and what topics seem to be the most relevant that we can share and hopefully propel us all to even greater success. So today we're going to talk about collections, and this is going to be relevant for those of you that are white label partners. As a white label partner, you control the client agreement, you control the terms, conditions, prices, but unfortunately, not all of your clients will do what they say that they'll do. And so we're going to talk for a few minutes this morning about how we have revamped our collection process, and some of that may be relevant to you as well, but we'll dig into that. All right, so from an introductory perspective, we're going to review our new collection process for clients. And unfortunately, on occasion, we have distribution partners. We have some white label partners that have signed up and they've not done what they promised to do. So this is relevant from our perspective for both clients and distribution partners who are not compliant. We're not going to use legal jargon. You know, some of us have gone through business law classes or paralegal classes. Some of you are attorneys, but we're not going to use a bunch of legal jargon that may not be familiar to everyone. We're just going to look at it in simple terms. So let's start by why is this relevant? As a white label partner, you may have clients who fail to do what they promised to do. And I wish that weren't the case. And I don't know if it just borders on some people are financially illiterate. You know, they'll sign a contract with you or with us and then somehow think that it doesn't apply. I don't know what gets into the minds of people when they don't do what they promised to do. But the bottom line is there's probably three scenarios that you're most likely to be impacted by. And so the first of which is you sign up a client and then they fail to participate. And we see this on occasion. A client will sign up, they'll agree to the terms and conditions, and then for the access to capital program, and then they do nothing. And that is, of course, a breach as defined in the agreement. So, of course, we want to minimize all of these breaches. We want to reach out with understanding and compassion and love and try to help people engage. But unfortunately, we have to look at this objectively. There's going to be some people that sign up and then they don't actively participate. And again, with the standard agreement language, that would be a breach. Second scenario is they don't accept first tranche financing. So what is the proposition that you are making as a white label partner to your access to capital clients? You're saying, hey, there is a deposit. You're deciding if it's refundable or not. Normally it's $2,500. So I'll just use that normal scenario. Hey, there is a $2,500 refundable deposit. We disclosed it in the agreement, but you as the white label partner are not going to invoice them until after their first round of capital. Now, some people will just want to pay it up front and be done with it. And we see that frequently, not all the time, but frequently. But the general process is they fill out the Adobe proposal application, funding proposal application, and then we get them some offers. They either get cash offers or other financing offers. Everyone gets approved financing. Different people get different terms. We have a client, Gregory, this morning. He just got another $20,000 this morning. Well, we were notified this morning. He probably got funded yesterday, but the bank notified us this morning that he got another $20,000, which is his second cash infusion from his first tranche of financing. But the point here on number two is some people won't accept the first tranche financing, and technically they're not required to. If you look at the agreement, it's okay if they don't like the offers. You know, let's say Gregory this morning or yesterday said, no, I don't want that 20,000 offer. If it's not at least 25,000, I won't take it. Or if the interest rate's above 3.5%, I won't take it. Well, that's fine. Our agreements are not oppressive in terms of requiring our agreement templates, I should say, that you're using as a white label partner, are not oppressive in terms of forcing people to accept funding offers, but the market, you and I are not the lenders, we're the technical advisors. So they get the offers that they're credible enough for, they can accept or reject those. If they don't accept those, then you would normally invoice them for the deposit, maybe refundable, maybe not, depending on how you have it set up. But the point is, this is the second most active trigger for a breach. They don't accept the first tranche of financing, and I should have put on here, and they don't pay you the deposit, because that's the way the agreement's written. If they don't accept financing offers, at least one offer to cover their deposit, then they need to pay it out of pocket. But again, everyone will be offered, no matter how bad their credit is or how bad their income is, everyone gets financing offers. So that's the second. And the third, I mean, you hate to see when this happens. You hate to see when this happens. But there's cases where clients will get funded, not too often, but clients will get funding and then they still refuse to pay. And, we don't want to make this a psychological discussion, but I don't know. So some people lie. Right? I don't know why they lie, and I don't know what their motivation. Well, I guess their motivation is not to pay, but that'll happen. So on occasion it'll happen. So these are the three most frequent scenarios that you will probably be impacted by. So you need to have a process in place to deal with it, and that's what we're building up to as we go here. So for us, we have some direct clients, so we have to deal with these issues. Plus, then we also have white label partners who sometimes don't do what they promise to do. And it varies. So we have some white label partners that sign up and then they're not actively participating. They're not doing at least 8 a month. We have some white label partners that help their clients get funding, and then either they don't collect from the client, and which of course we do a 50-50 split with, or they collect and they just don't pay us. It's bizarre how people act sometimes, but regardless, we're in this together. If you're a white label partner, you're contracting directly with clients. In summary, these are probably the 3 issues you'll face most, and we're right in there with you because we face that. Plus, we have white label partners who sometimes don't do what they promise to do. All right, so next, contract law simplified. Again, there's a lot of legal jargon I could put in here, but to keep it simple, we won't. We'll just narrow it down to 2 bullet points. But there's solid grounding behind each of these bullets. Number 1, written agreements, written contracts are binding, and they will be enforced by the courts. The agreement template that we've provided you to use has been reviewed by attorneys. It says that everything's in the agreement, nothing verbal outside of it can change it without a written addendum signed by both parties. It's well written. It's not punitive, but it's well written to protect you as a white label partner. And people sometimes aren't smart, I guess is the easiest way, and they'll just think, oh, that doesn't apply to me. Or we've had people that have signed an agreement and then they default, and then because the goal should always be to try to resolve an issue, right? You don't want to take everyone to court. You don't want to sue everyone. It's like, well, what's wrong? Why aren't you doing what you promised to do? And we'll have some people say, I didn't sign that. It's like, no, you did. Here's the date, the time, the IP address of its terms and conditions, or here's a copy of the signed Adobe agreement. But people, I don't know. I can't explain it. So all we can do is try, what we should always do is follow our side of the agreements, you as white label partners and us as your resource, and then ask people to do what they promise to do. And if they don't, they're going to face the consequences. And I don't mean that negatively. It's just that's the way it works. If you go buy a house and you don't pay your mortgage, it's not going to go away. You're going to lose your house. If you go finance a car and you don't pay the car payments, that car will be picked up sooner or later at some point during the night, no matter where you hide it in a parking lot. And when it comes to consumer debt, like we're talking about here, If you have a good collection process, you will collect, and it's going to be so expensive for them. And I don't say that with glee or happiness, but they're going to end up having court costs and collection fees and late fees, et cetera. It's going to be so much more expensive to them. And so we don't want that. We just want what we want, and what I presume you want with your clients, and what we want with our white label partners is, let's just all do what we promised to do. Let's do that. That was the commitment that was made. All right. So again, there's terms like estoppel and other legal terms that we could go over that makes this sentence incredibly powerful. But if you'll just take it as two simple bullets, written agreements are binding. And for them to say, oh, I didn't understand it, or I changed my mind, or I want to terminate, I don't want to be responsible, that's all nonsense. And I feel bad for people that think that they can execute agreements and they're not binding. Because if you have a collection process, and I'll say this, and again, one of the reasons I didn't want to record it, because I wanted to have more of a candid conversation with you. But if you're a white label partner and you do what we say that we'll do, you'll make a good income. If you're a white label partner and you do what you say that you'll do, plus you have a good collections process, you'll fund your retirement. Because unfortunately, there are going to be some of your clients that are non-performing. It'll create non-performing debt. And the way that you handle your non-performing debt, your breached agreements, is going to create, frankly, your long-term wealth. There are many examples of companies that have created massive wealth from non-complying agreements. So certainly we don't want people to breach. We want people to do what they say they'll do, and we want to do what we say we'll do. But I guess I'm giving you the lemonade versus the lemon pitch, is that these non-performing agreements are worth a fortune to you. We were visiting with an attorney that works with a large dialysis center. It's a national company. I won't mention their name. And so dialysis is pretty sensitive, right? I mean, if you don't have dialysis and you need it, you'll probably die. And so this large healthcare entity has a huge collections team composed mainly of paralegals and attorneys, that if people don't pay their portion of the bill for dialysis, not only do they refuse treatment, so you will die, they will sue your estate and they'll win. And so, you know, what you and I are doing is not near as grave as that. But the point is, if you have a strong collection process, then you have what's called creditors' rights. You have the ability to collect what people owe you. All right, so let's go through our collection process updated, and then we'll talk a little bit about what you may want to do on your side. So we've had numerous consultations, and so here's our process. So we're going to start from a white label partner. The rest of this is really more about clients, but from a white label partner perspective, we're going to start having monthly reconciliation calls. So it won't be me, it'll be one of my staff that will visit with each white label partner and say, okay, how many clients did you enroll this past month? Let's say in December. Was it 8 or more? If it wasn't 8 or more, you're not in compliance. What do we need to do? What can we do better? What can we do to help you? Because you're in default. You've defaulted the agreement. You've breached the agreement. So again, you can see it's not about, oh, here's some punishment, but instead, what do we need to do to get it on track? Typically, there will be an invoice issued because all of the white label partners promised after an initial grace period month to help at least 8 clients a month to a week specifically. And so there is a financial penalty, but our goal is not to collect that financial penalty. It's what can we do to get this on track? So by having the reconciliation calls, we feel monthly starting in January, we feel that we can do a better job of supporting each white label partner to make sure that we're doing all that we can do, make sure that they're holding their clients responsible. Because again, invariably you will, if you're doing any volume at all, you'll have clients that will stiff you, using an unofficial verb of one of these 3 areas. We want to make sure, because we both have skin in the game there. All right, so that's number one. And number two, which is really more of our collection process from our client perspective, but I guess it could apply to a white label partner as well. But we will send an invoice. We've fully migrated over to QuickBooks now. And so you may or may not want to use QuickBooks. You may or may not want to generate your own invoices. Maybe you want to outsource that. But I think it's important, and it's what we're doing now consistently, is to get invoices out that clarify here's the amount due and here's why, with really the intent of how do we resolve this, because we don't want people to breach. We don't want people to have punitive payments. We want to resolve the problem. But if they don't, it's not going to go away. It's an obligation. So we would recommend that you consider having an invoice system for when clients don't do what they promised to do for you in your agreement. The next step is to escalate it with a demand letter. So now I'm getting into a little bit more legal jargon, and I promised that I wouldn't, but this is important for you to understand, at least at a high level. The way that a demand letter, most courts, by the way, require that a demand letter is sent and 30 days elapse before a lawsuit is filed. And so the demand letter doesn't have to be written a certain way, but it should clarify, here's the amount you owe and why. And then more advanced demand letters include, and many of you may not be familiar with this, but this is powerful, it includes a preservation demand. And what that means is the defendant, the person that you're sending the demand letter to, the person that owes you money, is put on demand. They're notified that they need to start retaining anticipated documents that are going to be part of discovery. And then if they don't do that, that is bad, and they could be arrested by the courts for not complying with the discovery request. So what would be included? It can't be punitive. It needs to be documents that are relevant to the case, but things such as bank statements, including PayPal, Zelle, Venmo. It could very well include, like in our case, we have a white label partner. She's gone rogue. We got her client funding. He admits he got funding. He says he paid her. She says he didn't pay her, and she's refusing to pay us. And so in that case, what the preservation demand would include for that client, we'll probably have to also sue that white label partner that's in breach, is emails. We would require emails from a certain date to a certain date that could include reference to the funding, text records, cell phone records. And so it depends upon the circumstance, but the point is the preservation demand is serious, and it's more than just saying, hey, they owe you money. It's putting them on notice of the documents that they need to start retaining, because they're going to be included in a discovery request, and their failure to do that could land them in prison. So in our world, we have the new demand letters and new format and process set up. So they're going to start going out soon. We started invoicing through QuickBooks a couple months ago. We're almost at $10 million right now of AR in QuickBooks, just since we started using it in September. So these demand letters will start to go out. And then typically, so what I said is that most courts are going to require that a demand letter be sent at least 30 days prior to filing suit. Also, the courts are typically wanting to see that you've made an effort to try to resolve it, because you don't want to waste the court's time. And so it's very common in a demand letter, because with the invoices, we're trying to explain, hey, here's the money owed, why, let's get it resolved, right? We mentioned that. We want it to be resolved. Once we get to the demand letter, it's often beyond resolution, but certainly then, because there's a full-fledged breach, what could happen then is offering a discounted settlement or even a payment plan to resolve it, because we don't want to go to court. We obviously won't. You wouldn't want to make, and we won't make blank threats to go to court. That's the process, which we'll see. But we don't want to go to court. We want to try to resolve it. But If they don't resolve it, then for our clients, our agreements sets forth the venue as being Wood County, Texas, because that's where we're at. So your agreement as a white label partner needs to state what the venue is. If the agreement states the venue, then that is the venue. So people from all across the country, if they want to defend the lawsuits against us, will have to come to Wood County, Texas. So they might be in Hawaii or Maine or Florida or Seattle. It wouldn't matter. That's what the contract states. If the contract doesn't specify venue, then they could argue that it should be a court close to them versus a court close to you. So that's why it's advisable for the agreement to be very clear and very specific, like ours is. Now, I know some of you, well, I guess all of you that are white label partners are using the template agreement that we've provided. I don't know that you would want to leave the agreement template as Wood County, Texas, because that's not where you are. That's not where they are. So it's probably not convenient to either one of you. So normally you would make it where you are. If you leave it vague. So again, the synopsis of contract laws, if it's stated explicitly in the agreement, the judge, the court is almost always going to follow what is in the agreement. If it's not explicitly stated in the agreement, then there's a lot of discussion and challenges. And so if you don't state where the venue is in your agreement, then it could be argued that it needs to be somewhere else. But I don't know that I would leave it as Wood County, Texas, unless you're planning on selling to a debt buyer in Wood County, Texas, which we'll get to that in a moment. All right, so now let's wrap it up. So what we are encouraging our white label partners to do is you should have a collection process that's set up that you follow, and that's going to protect you, and the consistency is going to probably allow you to collect more money. Because again, we want clients to do what they'll promise to do, and of course you want to do what you promise to do, and we'll do what we promise to do. But with that being said, if they don't, you should have a process in place. Ultimately, you're going to need to decide, and I guess this is maybe the most important section on the whole page here, is ultimately you're going to have to make a decision. You're the business owner. You have the contract with these clients, that you can either take what we call the non-performing debt, the agreements whereby there's been a default. You could either submit them to a collection agency. Collection agencies often won't charge you anything in advance, and then they'll go through the collection process, which includes reporting the defaulted amount to the credit bureaus. I'm not a big fan of that, but you certainly could do that if you wanted to. We do have a collection agency under retainer. We do send files to that collection agency, and then we've used two others earlier this year without success to our expectation. I'm not big on the collection agency, but that's one option. Another is to litigate, and that's really, frankly, what we've decided to do is to litigate every defaulted agreement, whether it be a client or a white label partner or what have you. Not to be punitive, but if an agreement's broken, we're just going to let the judge decide. And as I mentioned, 99.999% of the time, the judge is going to go off of the written agreement. The third option that you have is you could just write it off, just say, oh, never mind. And in some cases that may make sense, but that would be up to you. And then the fourth option, which we've talked some about before, is you could technically sell that debt to a debt buyer. But I will let you know that there's a couple different points in time that you could sell the debt to a debt buyer. So we're not talking about factoring accounts receivable here. So this would be a debt buyer in this term is buying a debt that has been defaulted, and you could sell it to them once you have invoiced them. I wouldn't send a demand letter out if you're not planning on litigating. They'll do that if they buy that. But also you can wait until after you've gone to court after you've won, which you're going to in almost every instance, and then you could sell it at that time for even a higher amount. But we do have debt buyers that are willing to buy non-performing debt. All right, so with that being said, let's field a few questions and then we'll wrap it up here at the bottom of the hour. Who has questions on the new collection process, what we're doing, what you can expect? So if you're a white label partner and you hear of others, other white label partners or clients or what have you that are getting demand letters, it's part of the process. We will have already invoiced them. We will have tried to resolve it. They didn't want to resolve it. And so the demand letter is a forewarning, both to preserve documents and that a lawsuit is coming, and then we're going to file here. In your case, again, we're recommending that you set up a process that you feel comfortable with, but it may include any combination of these 4 ways to resolve a non-performing debt. All right, so who has questions? All right, so Timothy's asking about reconciliation. So Timothy, frankly, Timothy's one of our white label partners, and he had some issues in his life where he hasn't been meeting the performance expectations. So Timothy, all you'll need to do, just like we've talked about, is schedule your reconciliation call. If you need that information, email me and I can send you the scheduling link. And we want to help you get on track. That's all we want to do. We want to have a good, successful relationship. We have had a few, not too many, white label partners that said they don't want to continue in 2022. They want to wrap it up this year. That's fine. So then what we have to do during this reconciliation call is figure out what to do with the clients that have already been executed to make sure they're taken care of properly. And then our compliance department will work with the white label partner to help them exit the agreement if that's what is desired. All right, so Zahn asked a good question about selling to a debt buyer. So the amount of money that you would make by selling a non-performing debt will be contingent upon what the debt buyer is willing to pay. As a white label partner, normally that the client, assuming that they didn't do anything, it didn't pay anything, they've defaulted on the refundable deposit, which is normally $2,500, normally refundable. And then secondly, the client also owes you the performance fee. Most of you are doing 10% with a minimum capital raise of 100,000. So a defaulted client would owe you normally, if your agreements match what I just described, $12,500. So that's how much you would invoice them for, $12,500. Now, some of you are just going to invoice just for the refundable deposit if that's where they have breached. But ultimately, the agreement by normal design is they owe you $12,500. And so that's often what the invoice would be. That's what the demand letter would be. Maybe you offer to settle it for something less than that or set up payments. But then if you sue, then normally you're going to sue for the $12,500 plus any late fees. That wasn't Zahn's question. Zahn's question is, well, what's the debt buyer going to buy it for? Well, the debt buyer is going to look at how many files do you have to sell, and how is the agreement written, what's the credibility or collectability of the clients. And so the debt buyer will review the portfolio, that's what it's called, and then make you an offer. So I can't speak on behalf of that. You'd have to put a spreadsheet together with all the debts. They're going to look at your agreement templates, and then an offer would be made. Marcelo brings up a great point. He says, well, what if the client says that he's not doing what he's supposed to do? Well, Marcelo, if as a white label partner, if you have a client that says you're not doing what you need to do, you want to correct it, right? You either want to do what you promised to do, or reference the client to the agreement, because sometimes clients will make up things, and we see that they'll make up their own rules that's not in the agreement. So they're like, well, you're not doing XYZ, and it's like, well, XYZ is not in the contract, ABC is. Well, I want XYZ. Well, that's not what we agreed to do. So Marcelo, you're bringing up a great point. Yeah, if you have a client that's coming to you and saying that you're not doing what you should be doing, you want to resolve that, of course. And then also the way the standard agreement template states is that at any time, if a client feels, and it's true for you all as a white label partner, if a white label partner doesn't feel that we're doing what we have promised to do, and or a client doesn't feel like that we've done what we're supposed to do as agreed in the contract, then we've agreed to binding arbitration. And so the client can trigger that, and then the two parties meet with an independent arbitrator to resolve it. I can tell you that we've never had we've had zero arbitration claims filed against us by white label partners and or clients. So thus we've lost zero. So if you're using Marcelo, our normal agreement template, it has the binding arbitration for your clients. So if a client does come at you and say that you're not doing what you promised to do, try to fix it. If you can't, then say, well, I don't want you to be disgruntled. Let's sit down with an arbitrator, an independent third party. So use that arbitration provision. It's not a punishment to the client, but it is an opportunity for you to get an independent third party involved, Marcelo, to resolve it. And again, more than Better Business Bureau or reputation postings or what have you, what really matters is what's in the contract, and if you're doing what you say that you'll do. And then if you're not doing what you'll say that you'll do, or we're not, then of course, then the client or the white label partner should be following the arbitration provision, because that's what was agreed to in the agreement. So that's my answer, Marcelo. If the client feels that you're not doing what you should do, try to figure out why, try to resolve it. If you can't, then encourage the client to use arbitration so you and they can sit down and get it resolved. Is that helpful, Marcelo? But Marcelo brings up a good point. That's usually the most common issue for a disgruntled client, is that they change the rules of the game. They made up some requirement, some expectations that's not in the agreement. It's not what was promised to do, and that's what they want. And you're not giving them what they want. And so again, all you can do is treat them with love and compassion and care and say, well, I'm sorry, Joe, that's not what we said that we would do, and that's not how it works. And you're asking for something that's different than what we do. So let's figure out if we can resolve it. But if not, I don't want you to be frustrated. Let's sit down with an arbitrator and resolve it. And that's the way arbitration is great. It keeps it out of the court system. So we use the court system if there's a failure for the client to pay, but for anything else, then arbitration is used. And again, we've got on our end, we've got a perfect track record. We've lost 0 arbitration cases, and more so, we've literally never had even one arbitration case filed against us. And we help work with a lot of people. So I don't think that you're going to find yourself ending up in arbitration very often. But if you take our mindset, I would encourage it, right? If there's a disgruntled client, ask them to follow the agreement, ask them to use arbitration to resolve it. All right, well, that is the new collection process, our mindset, our process, what we think that you need to do, and let us know if there's anything we can do. Have a great day. We'll see you back tomorrow morning. Bye-bye.